Thank you all for joining us, both in person and online, and I'd now like to hand it over to Greg to get us started.
Thanks, Megan. So, since the last presidential election, there have been a couple changes in U.S. immigration law and policy, well, specifically policy. And I think it's probably fair to say, I'll look for nods or shaking of the heads here, that things are on a trajectory to change more than they have in the past 20 years since we had major immigration reform in 1996. Is that fair? And these changes are going to be felt especially profoundly here in the Pacific Northwest and in Washington specifically because of our great dependence on the tech sector. And let's not forget that we're a border state also. So we're really going to be in the heart of things as these changes come down the pipeline. This is intended to be a politically neutral discussion, so we're not intending to convey a partisan view of the changes that are happening, even though some of us feel strongly about the tenor of some of these changes. Really, our purpose here is to update people on the major policy issues that have developed since the election. You've got really some of the top speakers in the Pacific Northwest here to my left. Ching Ching, as Megan mentioned, is the president of AILA Washington. This is the bar association for all immigration lawyers. Tamina, I refer to as the celebrity immigration lawyer in Seattle. She's been featured in every publication and news outlet you can possibly think. And Dustin runs the immigration practice at probably the largest immigration law firm in the Pacific Northwest. Please jump in with questions as we go along. We want this to be a conversation as much as possible, both for folks online and those in person. And with that, let's go ahead and launch into discussion. Tamina, I'll direct this at you. What is the travel ban that we've all heard so much about, and what in the world is going on with it right now? Where do we stand?
Well, thank you for the introduction and the invitation to Sorry, thank you. Well, thank you so much for the invitation to be here and for the lovely introduction. The travel ban has been a very interesting time in immigration law because never in the history of immigration law in the United States has a group of people been banned in the way that it was banned in late January. So essentially the new administration took over the White House on January 20th. And then January 25th, there was an executive order that came out essentially saying people from 7 countries would not be allowed to come to the U.S. And initially, it was under any circumstances. So that brought a lot of chaos. And it was a Friday, 5 p.m., when a lot of lawyers had gone home. A lot of people had just started their weekends. And this was just unforeseen. So the chaos was also unprecedented. Initially, people were not allowed at all. So while people were airborne, they got to the airports and realized that they couldn't actually get out of secondary inspection. While people from 7 countries were actually banned from coming into the U.S., what we saw in practice were people from many countries. Would you agree? We found a lot of people from India and other countries that appeared to look like they were Muslims were banned. I'm going to be very, very brief. I'm going to try to be brief. Then, of course, Washington State brought the first case that had brought a stay nationwide. And then, of course, there was an appeal, and then the case went to the Supreme Court. Right now, the case stands at this. The ban is in effect, but there are caveats. So people who have close relationships with people in the U.S., and initially it was going to be parents and spouse and children. Grandparents were not considered close relatives. Now they are after the Supreme Court case. So people who have relatives in the U.S. can now travel in from those 7 countries. It must be noted that refugees are treated in the same way, even though they shouldn't be. And refugees who have bona fide relationships in the U.S. would be allowed to come in. So what happens next is we have to wait and see. I think there are timelines for the administration to receive reports, and we will see whether they lift the ban or have further restrictions on them.
They being the Supreme Court.
The Supreme Court, but I believe the administration has timelines on what they will be doing with these reports.
The internal review within Department of State.
Yes.
No, we don't have time to really drill down into the Supreme Court arguments, but just in the broadest sense, why and how is this travel ban being challenged in the courts?
If somebody wants to take that?
Sure. I think the travel ban is being challenged because, as Tamina said, it had never been done this way before. There's a strong argument that the way that the travel ban was instituted and the reasons behind it were unconstitutional. We've heard it referred to as a Muslim ban, and I think it's up to the Supreme Court to decide, due process, standing, everything. I think the fact that the Supreme Court has allowed the ban to be in effect while it's making those decisions, but with some caveats that a lot of people think are fair, is provides a little foresight into what their decision will be. So I don't think it will be that they will approve a widespread ban similar to the first one that came in January, but perhaps there will be a stronger look at who comes into the United States and why, if they have those business or family contacts.
And Dustin, tell me if you agree with this. I mean, basically, for the Supreme Court to have permitted some of the ban to be re-implemented basically means that the Supreme Court bought the government's argument that this had a legitimate security-related purpose, which has been the administration's position all along.
Sure. I mean, I would have to say that I'm speculating, but I think we can all agree that I think that does mean the Supreme Court thinks that at least there's some need to secure our borders or to be a little bit more secure. And I think that they found a sort of, I guess we can call it a common sense argument. If someone is already going through the regular FBI inspections and they're not raising any flags and they have a legitimate business or family need to come to the United States, then we can allow them in. And if they don't, then until we make our final decision, we're not going to allow them in, all in the name of security.
Well, the Supreme Court will be hearing arguments in October, and we will all be enlightened after that, I think. Mm-hmm.
Ching, do you have anything to add from wearing your AILA hat?
It's more my personal perspective or personal
it.
take on it. Reading the opinion, I tend to believe that the justices seem to avoid addressing the issue of whether the substantive part will prevail. Or when I read it, I think they seem to suggest that that's a question they're going to decide. Because right now we're talking about a preliminary injunction, right? If we're looking at the opinion from Justice Thomas, he seems to suggest that it should have been upheld completely, right? And he strongly believes that the government is going to prevail in court, but that's not my take on the opinion. And I would say I'm still hopeful, and from AILA's perspective, we are hopeful, and we're doing a lot of advocacy work in this area. So hold our hope high. That would be my take.
Well, let's move on to a topic that is just extremely important throughout Washington for sure, but especially here in Seattle, which is what is going on in the world of tech workers and high-skilled workers. What's happening with the availability of H1B visas? What is an H1B visa? How do you get it? And Ching, that goes to you.
Great. So I guess before we started, I like to tell my clients or potential clients that the rule remains the same as of now, which is pretty important.
The H1B rule.
Yes, the H1B rule. So H1B visa is probably the best known work visa, and sometimes it is referred to as white-collar visa. And the chances are, if you look around, you'll probably run into someone that is on H1B, especially if you go to Microsoft or Amazon. So it is a visa in very overly generalized term, it is a visa for specialty occupation, which normally means a job that requires a bachelor's degree in a specific field or area. And we can go into days talking about what that actually means in the eyes of the government. But so, yeah, a lot of, if you see a college graduate student who has a degree in computer science from a foreign country, the chances are this person will get an H-1B visa in order to get a job in the United States, and that's a pretty commonly seen pattern. I think the biggest thing about H-1B, what people know is there's a quote-unquote lottery. How that works is that there is an annual quota of how many H-1B visas are giving out each fiscal year. And so if there is a higher demand, the U.S. government puts in this quote-unquote lottery system, so they will randomly select whose case is going to be adjudicated. And the interesting thing is that only means that your case will be reviewed by the USCIS. So you could win the lottery but still lose your case. And that's, for immigration practitioners, that's very important to remind our client of.
And you mean they could lose because you win the lottery, so you get the Immigration Service to review your application, but the determination is made that you don't fit the criteria.
Yes, you still don't get the visa. And so normally it's a 1 to 3, that's about right, chance to be selected in the lottery, because the total numbers of the total number of visas is 65,000 for bachelor's degree and 20,000 for a master's. So we don't have that many. And one interesting thing I noticed this year was that the total number of applications actually dropped from last year. And I'm curious as to your opinion on that, like why?
You know, I think it was the rhetoric. Before we filed, I actually thought the numbers would be higher than the past years because the changes are inevitable and you want to get your H-1B now. So to see the numbers drop, and so when we say drop, it doesn't mean that there wasn't a lottery. There was still a lottery. But last year, the government had received 235 or 39,000 applications where there were only 85,000 available. And this year, the government received 199,000, which is a significant drop. So it was quite a surprise, and I think it was the rhetoric of the administration that might have caused that.
I would agree, and I also think specifically to the field of technology, as Ching mentioned, we could talk for days on what it means to be an H-1B and qualify, but one thing we do know is that the tech industry, software engineers, developers, computer programmers, with a caveat, use the H-1B category most often. And when you look at the companies that use the H-1B application the most, there are some very well-known technology companies at the very top of that list after spot number 3. Spots 1, 2, and 3 are actually really large tech consulting companies that use the H-1B category. In other words, they will interview and hire persons from outside the United States and then hire them as, for example, software engineer consultants, and then place them at third-party work sites. Often, the other people on that list, the other tech companies.
Who didn't win the lottery.
Who didn't win the lottery, that happens. And this year, what we found was really interesting. As Tamina said, there's a lot of rhetoric going on. The top 2 companies, which normally together maybe make up 20,000 of those 85,000 visas each year, and a larger number of the 230,000 applications, they didn't submit as many applications. One had a significant percentage drop, and the other company didn't submit any applications at all. So that's why we were predicting more than 239,000 this year and saw only 199,000. And I would say that everybody's being very tight-lipped about why. So it's really curious to see what's going to come in the next year or so for consulting companies specifically, because they are being targeted in the bills that are flying around out there.
So let's try to put some color on this, for businesses here in the Seattle area. What's the timeline for an H-1B, cradle to grave before the worker gets his his or her visa. And for this kind of changing environment, what is that meaning for your clients in the tech sector here in the Seattle area? What are some examples?
So the timeline for applying for and obtaining an H-1B visa is complicated, but normally you cannot apply until April 1st of a particular year, because that's the fiscal year mark. And if you win the lottery and if your H-1B visa is approved, you cannot start working on that H-1B visa until October 1st. One key note about that April 1st date, you can't apply until April 1st, and we usually say you can't really apply after April 1st because the government receives so many more applications than visas that they actually cut off the application period. Fortunately, they make the period last about 5 days lately, so you have 5 days to get your 200,000 applications in for those 85,000 spots. What's interesting is that many of the applicants are students who have recently graduated, or on April 1st, they may in some cases be graduating that May, but usually they graduate from school and they get 1 year of work authorization. So they're working with a company, they just graduated, they can work from May of this year to May of next year. Hopefully next April 1st, that company will submit an H-1B visa for them. If they don't win the lottery, then we have to look at their options, which may be an extension of their work authorization, or in some cases, going back to their home country.
Mm-hmm.
So this tech firm is trying to move forward. They're trying to ship some product, and it's a year before they even know if their workforce is going to be in place.
Right. Oftentimes, you just cannot predict what your workforce is going to look like when you rely heavily on the H-1B visa.
So, Tamina, do you have an example of how a specific client has been impacted by this? I was hearing NPR this morning, once again, Canadian cities reaching out to and advertising to tech firms here and in the Silicon Valley area, basically saying, you know, that process that Dustin just described that takes a year in the States, we'll do it in 2 weeks. So come up to us and we'll get you the flexibility to scale up your workforce.
I think it's a very interesting time in history to see what Canada does. Because everything that we're doing, they're just doing the opposite to make sure that they get the human capital. And actually, in the last few days, the Startup Visa program, something that I advocate for, was a pilot program in Canada. And just as we here find that the administration delays the sort of Band-Aid rule that we were going to get, they have made their rule permanent. So, and that was not in the news. The news item that you're talking about that was on NPR this morning essentially said that, you know, any workers that would be coming to Canada will have their process shortened to a 2-week mark. And what was interesting about that piece, they also said that they are seeing a lot of U.S. companies and U.S. workers going to Canada. So it's a very challenging time for businesses because they cannot predict how they are going to manage their own clients and their own products and their own services. So what Dustin mentioned about the timeline about October 1 is the beginning of the fiscal year, and you can apply for a work visa 6 months in advance, and that's where the April 1 comes along. So businesses are really looking at their fiscal years about what are they doing with their own businesses. So they try to plan for October 1. So while the processing of these applications that are pending should actually be adjudicated by October 1, if you're lucky enough to get selected, number one, and number two, if you are going to get adjudicated, you hope that you would have a visa in hand by October 1. But what we are seeing, and Dustin and Ching Ching can confirm this, often visa adjudications go beyond October 1. So not only are they facing the challenges of not securing people that they could want to hire, they are also facing the challenges of timelines. So what are businesses doing? Number one, Canada is becoming a more and more attractive option. And there are people who are either going to companies out there to position their employees, or they are actually opening their own branches in Canada, and that's a very common practice. It was in the news several years ago when Microsoft actually did that, and that's a very common thing for Microsoft to do. But smaller businesses are doing that. But the other challenge is about what else are they doing. Often they are now hiring people remotely. From whichever country that they can find their talent, especially with modern technology, that's possible. But these real challenges are sometimes insurmountable because Dustin and Ching Ching will confirm this. When we speak with our employer clients, they will tell you we cannot find the people to do these jobs. And USCIS just this past week had a
Immigration Service.
Yes, sorry. United States Immigration and Citizenship Services had a stakeholder meeting with the public based upon the new executive order that was signed by the new administration called Hire American, Buy American. And in that, USCIS said they are going to be scrutinizing and reviewing every work visa available, not only H-1Bs. So the changes that we will be seeing in policies will not be limited to just H-1Bs. They will be going far beyond that. Essentially, when somebody doesn't have an H-1B or they didn't secure it, we are looking at other options, just like Dustin mentioned. And what we will find in the coming months, that those other options that sometimes we can use, not all options are available, whatever options are available, those will be seeing changes as well.
Now, Tamina just mentioned the Hire American, Buy American executive order. Ching Ching, I don't want to broadside you with this, but would you be up for giving a thumbnail description of what that is?
It is an executive order in which it's really not, it is not a law, and it doesn't really change what we're doing right now. But I think it more of it sent out a message, a very negative message, and also reinforces a common misconception that H-1B visa or this particular category or any visa category is a way for U.S. employers to find cheap labor, which, as immigration lawyers know, is not true at all. And that was actually something I would like to talk about, because apparently a lot of news articles, and we see that the rhetoric addressing the visa as, our way to bring cheap labor to essentially lower the wage level in the United States, pushing the U.S. workers out. Is that how you two view it?
Not at all. And there's nothing cheap about an H-1B.
That's correct. We work with lots of companies, and we all speak in the community, and sometimes you get someone in the audience who says, you help companies take jobs away from United States workers. I can tell you that I've been working with Washington State also on a report about the tech industry and workers here. Companies are hiring tons of United States software engineers. But I think for one reason or another, we are actually not graduating as many engineers as people who we need. So companies are relying heavily on United States graduates as well as foreign graduates who hold bachelor's degrees. And as Tamina just said, for those foreign graduates, you are paying them a wage that the Department of Labor says you have to pay them. Plus, you are paying your immigration lawyer to prepare those visa applications. So
you are hiring American. You're hiring American immigration lawyers.
Right, you are. You are hiring Americans. You are fostering business. I think one important thing to note is that the H-1B is a program that was created in law and regulation by Congress, and it was created in order to help American businesses be competitive on the global marketplace. And it is just so interesting to now see, I guess I can call it attacks on the H-1B visa program that seem to be ignoring that initial reason that the visa was created. And one other thing I'll note, more than companies, also individuals. If you work with companies, you know that a lot of hiring decisions and human resource decisions now are more employee-driven than company-driven, because there is so much competition in the market, because we do need our tech employees so much. So we are offering things as tech companies like working from home and higher salaries and more vacation time. But those are people, those are individuals, and they are also listening to NPR, and they are also watching the news, and they see a lot of rhetoric that says, you don't want me here, and you're making this already difficult process more difficult, and this already really long process longer. So not only are companies looking to our neighbors to the north and south, but Canada and Mexico, but individuals are also.
Well, let's pivot slightly away from H-1B, although this actually does involve H-1B as well. Immigration and Customs Enforcement, ICE, basically the immigration police and immigration prosecutors, have substantially stepped up, quote, random raids. Tell us a little bit about what's going on there. What is a workplace raid, and what sort of Washington businesses are seeing those happen now? And that's for Ching Ching and Dustin.
Sure. So I do want to clarify the, using terms. So raid is a little bit scary, and that usually happens when ICE, Immigration Customs Enforcement, has been tipped off about a particular person, usually a person with a criminal background who's also here illegally. They will not usually raid an entire work site because one person might be working illegally. What they will do is a site visit and or an I-9 audit and or the Department of Labor will do an audit. So though the big scary raid may not happen, there are lots of ways that the government can show up unannounced at your work site and ask to see either a particular employee or your HR documents or personnel files, and they don't need a warrant in every single case.
So break that down a little bit more. You mentioned an I-9 audit. What is an I-9 and what is ICE doing looking at these forms?
Sure. So we all filled out a Form I-9 on our first day of work, and it's one of those things that just comes in your big packet of HR stuff, and it kind of gets overlooked, but it's actually the federal form that verifies your and confirms your ability to work in the United States. Most of us who were born here, our ability to work is based on the fact that we are United States citizens. So what a lot of people don't know is the Form I-9 is actually an immigration document. And immigration is the agency, or the Department of Homeland Security is the agency that authorizes or confirms or gives you the right to work in the United States. And they will either randomly or for a number of particular reasons come to your work site and ask to speak with someone, perhaps in HR or personnel, and then they will ask to see your I-9 files. And you typically have about 3 days to turn over all of your Forms I-9, and then they will conduct a review of your Forms I-9 and let you know what they find afterwards. And we hope that maybe there's just a few maybe you filled out this form incorrectly. What we don't hope is that you haven't filled out I-9s or that there are people who are not actually authorized to work in the United States.
And Dustin, let's say, I'm a small mom and pop shop, never heard of the I-9, or maybe I heard of it and didn't do it very carefully. What sort of liability might I be looking at if I faced one of these audits?
Right, so they have substantive violations and technical violations. Usually in an I-9 audit, they will let you know what your technical violations were. A form was filled out incorrectly. Sometimes not having a form can be a technical violation, maybe a substantive violation. You have a time period to fix all of your technical violations. If you have not addressed your technical violations, they become substantive violations, and then they will let you know what their decision is. And in extreme cases, like you knowingly hired someone who was not authorized to work, there will be jail time and significant fines up to around $16,000 per violation. But I will say, mom and pop shop, you didn't know how to fill out the I-9 correctly. You're looking at a technical violation and maybe a fine as low as $110 per violation.
No, Tamina, we talked a little bit about some numbers. If you're a small business owner, other business owner out there in the community, how are the odds increasing that you're likely to see one of these site visits?
I went to an AILA conference earlier this year.
American Immigration Lawyers Association?
Yes, the American Immigration Lawyers Association conference earlier this year, so that I could be updated on these issues. And I think what was discussed there, and I think we are seeing slowly, is these businesses will see about a third more audits than they have before, which is a significant number of audits compared to what has happened in the past. And these audits could be on the I-9s, but they could also be on H1B papers. So when you file an H1B application, there are lots of prerequisite compliance issues to do. And if that paperwork is not in the way it should be, then you could be fined for that too.
So basically ICE is coming in and saying, okay, is your foreign worker doing the job that you told us they were going to do?
Yes, and typically it's done by USCIS, the fraud department, am I right? And
That's right. USCIS has a special department that's about 9 years old called the Fraud Detection Unit, and they will show up unannounced at your work site if you hire H1Bs or another category, usually professional workers called L1s, and they will ensure that your worker is working in the job that you said he was in the application, that your worker is being paid the amount that you said you were paying her in the application, and you can be fined, or if the officer finds something wrong, that can then lead to a worksite raid or an I-9 audit or a Department of Labor audit. And we were told, one of our companies that we represent began to see more of these H-1B site visits, and we were told that that unit had a direct order from the president to perform site visits on 20% of all of H-1Bs. So remember earlier in the topic where Ching said, you might just run into an H-1B on the street. Think about how many people are in the United States on H-1Bs. If they are auditing 20% of these applications, then I think that shows a trend of really heightened enforcement and oversight.
So after you as the employer have made it through the gauntlet of finally getting your foreign worker in, after roughly a year, whatever it's going to be, then you've still got a 1 in 5 chance of getting a knock on the door from the fraud detection unit and making sure that all of your papers are in order.
That's right.
I think one thing to add to that, and this is a recent phenomena, airports and CBP offices are also scrutinizing H1B employees. So when an H1B employee is traveling and coming back into the U.S., that's an opportunity for immigration to inspect them, and that's where we're seeing another form of heightened scrutiny, where CBP is asking very intrusive questions about their positions, which they shouldn't. They need to know that this person is working and they are continuously working there and being paid. But the types of questions we are seeing are really in the form of what an adjudicator would be asking. What kind of job are you doing? What did your resume say? And in the past 3 weeks, I have heard from a number of lawyers that this has happened at various airports, international airports in the U.S., and some of these employees have actually been removed, something called expedited removal.
Which is a form of deportation.
And up until 3 weeks ago, I would not have worried about one of my employee clients traveling back into the U.S. If they were turned back, I'd say, well, just get another visa stamp and come back. I would not have worried about the extent of worry I have now. Now I have to basically go and educate every one of the employee clients to even the terminology that's being used by CBP officers are being misused. And the misunderstanding of terminology is affecting the way people are being treated. So from the time somebody applies for an H1B to the time somebody actually has an H1B, the cradle to death, you are now going to be seeing problems throughout the process.
Megan, let me pause for one moment. Do we have any questions from the online audience?
Earlier inquiry about the travel ban from 1979 under President Carter and the Iranian nationals. I thought it was a bit interesting, but I didn't want to take away from your H-1B discussion.
Well, we've kind of moved on, so perhaps we'll reserve that for the end.
If you want to comment on it later.
I want to move on from worksite visits unless anybody has a pressing follow-up on that. And to move on to the discussion of sanctuary cities, which is something that we've heard a lot about. To what extent is that a legal term of art that actually means something versus something a little bit more vague? Basically, what is a sanctuary city, and what authority does the federal government and administration have to dictate municipal policy in cities like Olympia or Bellingham or Seattle? Dustin.
So I'll define it, and then we can have a very interesting discussion about that because that's up for debate. But sanctuary city is not actually a legal term that exists in law, although it probably will soon. Instead, what it is an idea that has come up, and basically municipalities are saying because the federal government, the administration, the president wants an increased enforcement and heightened, stricter laws. That's a federal issue, and so you should be using Department of Homeland Security officers. That's what ICE is for. That's what Customs and Border Protection is for. We don't want to use our local police department funded locally to further the administration's mission of this heightened enforcement. And we're not equipped to review immigration documents and arrest people and hold them. So we are taking a stand, if you will, and saying that we're not going to do that. And so it's in that way it sort of becomes a sanctuary for people who may be underdocumented to know that any encounter they have, at least with local law enforcement, will not lead to an arrest or deportation immediately.
I want to add to that. I think there's a misconception from the public that sanctuary city means that immigration will not touch you at all, and that's not the case. It really means that the police will not be looking at your papers like there is law now in Texas saying, show me your papers. That will not happen. But ICE and CBP will still be able to detain you if they wanted to.
Yeah, so based on my very limited criminal defense experience from my past self, so at a policy level, if you, even if you got arrested, like say in Seattle, it is not customary for the police to contact ICE, or there isn't a directive for that. So you wouldn't be worrying about your client ending up in a Northwest Detention Center because of say a traffic stop or anything that's not related to immigration violation.
As a bit of a teaser, we're going to be hearing more from Lieutenant Diaz with the Seattle Police Department next week about the particulars of how SPD handles immigration issues.
To address your question on what authority they have and how that can change, there's been a lot of news about the administration sort of reaching out to those municipalities who claim to be sanctuary cities and saying that we're going to pull funding and pull local funding. I don't have any anecdotes to that regard, but to follow up on Tamina's Texas example, I am from Texas, and I watched something very interesting happen in just a short time period from January of this year to most recently when that Show Us Your Papers law passed. The big cities in Texas all basically said we're going to be sanctuary cities. We're not going to use our police force to go after people. And the federal government and state government actually sent Customs and Border Protection agents from other cities around into those cities to start making arrests for people who were here illegally. And then the state government got involved really quickly and said, okay, cities, so you don't want to use police to police illegal immigration? Well, then we're going to make it law, and you have to. And so they moved really fast on a statewide. So I think it just is very interesting to see how sanctuary cities can say, we don't want to use our local police to do this because it's not our policy or because we don't have the resources, and how that can be changed so quickly. So I think we'll be seeing that all over the country, different ways that this changes. And I think every city will be different based on state law and federal law.
Now, I guess one last follow-up on the sanctuary cities, and this is an important one for the audience to understand. You think about municipal government down here. Doesn't municipal government answer to state government, and isn't federal government above that? Why can't the federal administration, which is the boss, direct the city of Seattle in terms of how Seattle conducts its policing policy? Isn't the federal government the federal government?
So my answer to that would be the law is complicated. and more than that, I think funding is very complicated. And I think, municipalities and states both rely on the federal government. States and federal rely on municipal, and it's a weave. It's a complicated web.
And the direct answer is no, you can't. The federal government simply does not have authority to direct policy in a municipality. And what they can do is potentially remove funding from the municipality, but
But they won't because of that, because they all rely on each other. But right, no, they cannot. And so that's why they've tried to direct them by removing funding. And we haven't even seen strong examples of that, because I think it would just be too complicated logistically. But again, immigration lawyer, not municipal lawyer. I'm very curious to see what happens in each municipality across the United States.
I want to add a couple of things. We're very lucky to be living in Seattle with such progressive leaders. And the city of Seattle filed a lawsuit in the federal court based upon the fact that the constitutional spending power is being infringed. And that's currently, pending, and we'll see what happens with that. But having spoken to police officers and chiefs a number of times, and you will hear about that next week, police officers are policing. Police officers are dealing with crimes. Immigration law, as you can already gather, is one of the most complicated areas of laws. And you can't expect the police to be able to understand any of it. So to ask the police to do something that they are not experts in is a very challenging issue for cities. But what they are finding also is people, the public that need protection with the help of the police, are now not calling the police officers. There is a huge reduction in calls to 911 around the country, not just Washington State. And victims of domestic violence, for example, are still vulnerable and even more vulnerable. So these issues are actually have far-reaching consequences. And what states will do, it will be interesting to see, because the federal government is trying to put handcuffs on states. So it will be interesting to see where we are in December 2017.
Shifting gears basically entirely, Ching, what is Deferred Action for Childhood Arrival, sometimes referred to as the DREAM Act? Who does it impact, and what is going on with it?
In overly general terms, it is a program that could benefit undocumented individuals that arrived as children.
Arrived in the U.S. as
in the
young
U.S.
children.
as children. So the most commonly seen cases will be children who were brought by their parents, even as infants or as very, very young minors. They arrived in the United States not knowing anything about immigration law, went to school, integrated, thinking that they were U.S. citizen all their life, until one day they were told that they don't have any papers, or they couldn't either get a scholarship or financial aid or go into college or get a job. So it is a program that was intended mostly for those individuals.
Created by the Obama administration.
Yes.
And then throughout the campaign, we heard a lot of very strong rhetoric from the now president that DACA would be on the way out as soon as he took office. Did that happen?
DACA is still intact as of now. There was an extended DACA program that could have brought in DAPA that was proposed last year, right? Last year or the year before? It went so fast. But that is not in force because of a lawsuit, and that happened during Obama administration. So Trump administration actually didn't do anything with regard to that. But yes, ever since Trump took office, everybody, I would say literally everybody who knows about the program, is somehow involved in this program, is concerned or is worried that something's going to happen to it, because it is only an executive order, which means that Trump can undo it relatively easily. But as of today, it remains in place. But we have seen, say, long delays in adjudication or denials, and those things, again, we don't want to speculate into that, but it probably has something to do with the overall policy change or the overall adjudication environment.
And we have thousands of Washington residents who are on DACA,
Yes.
it's not technically a status, but on DACA, putting your finger in the air, feeling the breeze, what are we thinking? What's the future of this program? If you're a kid who's just out of high school, entering the workforce.
Before we do that, I wanted to clarify that DACA, Deferred Action for Childhood Arrivals, is not a status and is not a path to a green card. It is, and Greg just said it's actually not a status. It's literally deferred action, and what that means is the government is saying we're going to defer the action of deporting you. So it's pretty far from a status. We're just not going to deport you right now, and we're going to give you a work authorization, which is nice. So you can actually get your driver's license and work in the United States and pay taxes. So, for those reasons, lots of people like the program. A couple of million people have applied and benefited from it and work, and they get their 2-year employment authorization document, and they apply and renew it every 2 years. But as Ching Ching said, we're now starting to see those adjudications of those renewals take longer or be denied when they've never been denied before.
And that might be a really good indication of how up in the air immigration policy feels. Because just yesterday I was on an immigration lawyers messaging board, and everybody was saying, hey, DACA applications are going so fast. I've never seen them go this fast before. So here's everybody on the panel trying to guess which way the winds are blowing on this policy that impacts, as you said, millions of folks in the U.S.
I think what's clear is there's a risk of it going away. And that risk is what is causing a lot of anxiety, because these children have now come out of the woodwork, so to speak, and the government has their information. So if they did decide to do away with this program, it would be very easy to round these people up and deport them. So I think the trouble is we're in at a time in history when we are seeing the rhetoric of immigration be a way to scaremonger and cause anxiety. And as immigration lawyers, I don't think our jobs have been more difficult, because clients will want a straightforward answer, and that's something we cannot give them. So for DACA recipients in particular, who have no other alternative, if the program is taken away, they will likely be deported. And then what do we do? So what's the solution? We need comprehensive immigration reform. We were very close to it in 2013, but without a law coming into play to help individuals, executive order after executive order will just be a way to, executive orders are a pawn in the entire game. So if you care about immigration reform or immigration in general, or your neighbor, your friends, your job is to speak to your federal representative and ask for immigration reform.
And there is a piece of good news. 2 weeks ago or a week ago, the Senate, right? The Senate passed a proposed bill, a proposed DREAM Act, which could essentially make DACA program permanent. There isn't much update on that right now, and nobody knows whether it's going to get anywhere. But that's at least a positive signal that our legislators are working on this. They're looking into this issue, and there is some hope that we will have a more permanent program that will be a lot harder to be undone. And so there is hope there.
And this is something that historically has had a lot of bipartisan support in both the House and the Senate.
Yes.
Right. DACA was President Obama's policy because the DREAM Act couldn't get passed for about 20 years. And so now we're seeing, I think, a couple of bipartisan bills to resurrect that DREAM Act. So, I mean, as Ching Ching said, it's very new, but fingers crossed, it's a little bit of positive information. And as Tamina said, this would be the time to contact your representative and senator and show support for that if you would like to support that.
So, new topic, and I guess we'll make this our last one, after which make sure to answer any questions in the audience, is obviously Seattle, not all of Washington State. For the huge swath of Washington State that relies so heavily on the agricultural industry, I mean, we've seen years now where fruit has been rotting on not the vines, but the orchard trees. what has been going on, and have things gotten any worse, or is it just the same old bad? How have businesses been impacted in terms of being able to get seasonal workers to do that work?
So there is a visa category called the H2A for seasonal agricultural workers, and to state it briefly, there's a lot of hoops that you have to jump through to get agricultural workers here temporarily and prove that they are then going back to their home country, often Mexico, but also other Central and South American countries and all over, and then bring them back again the next year. And it is expensive, and there's a lot of time and money that employers, particularly farms, pay for these workers. And so while we haven't seen any changes yet for this administration, we have seen talks of different types of guest worker visas. It at first seemed like it might be easier to bring people here on the short term, but we just haven't seen a lot of movement in Congress on the guest worker program. So for the time being, farms and other agricultural employers have to rely on the existing sort of clunky, expensive program to get workers here every year. And we represent farms who you go through this process. It takes about 4 months, a lot of back and forth, and then you get someone here and they work for about 9 months and they go back to their home country, and you have to pay for housing while they're here. And they do that every year. And I think that's why so many employers are not relying on that program. It's just too expensive.
So when we see those reports about farms that literally aren't able to get workforce to pick their fruit, is that because they've reached some sort of a cap like the H1B, or is it just because the whole process is too laborious and expensive?
Both. So there are a cap on all of the temporary workers, and we see sort of not exactly related to ag, but there's a similar temporary seasonal worker for every type of seasonal work except agricultural work called the H2B, which reaches its cap every year and was just extended, and we can talk about that.
Could we talk about that?
Yes, let's talk about it. I'll let Tamina talk about it.
Well, the H2B program, which is for seasonal workers, had reached its cap. And then about 3 weeks ago, the cap was lifted and the extra visas were made available. That very same day, we learned that the resort called Mar-a-Lago had applied for 70 of those visas. So it's interesting times to see what is going to happen with visa categories and who needs them, who's going to use them, essentially.
Right. The H2B process is very clunky and long, like the H2A process. And it was, given the time period of the fiscal year when that cap was lifted, many of us thought, well, how can we even go through that whole process and apply for more visas? So it was interesting that Mar-a-Lago applied for 70 of them.
Well, let me see if there are any questions in either of our audiences, and then I'll close by asking each of you if you have a single, takeaway message you'd like the audience to have. Megan, anything from online or from anyone in person?
Yes, I'd like to contribute one online. We have an attendee who is curious, posing the question to everyone.
I can repeat it.
How have the shifting federal immigration policies affected each of your individual practices, sort of making this presumption that you have had some changes, and that's...
I can answer that. So my practice, which is different than the focus of the panelists, is on helping families unite in the U.S. And really there's been very little change in that area because the existing laws as to how you immigrate based on, for example, a marriage or an engagement to a fiance haven't changed. And so there's been a little bit of concern about ratcheting down of standards at U.S. consulates, but really things haven't changed. So although there's a perception that there's a lot of turmoil, actually in our day-to-day practice, at my firm, it hasn't changed a whole lot.
I think for me, it actually poses more of a challenge on client management than the substantive practice of law because of the fear of uncertainties or the fear of change and like the sense of urgency that wasn't there before. Because in the past, if you have a client that needs a visa, like we know, we don't always know, but like we will know when to plan ahead. But with, all the unknown, clients tend to call early or tend to say, oh, do I need it now? In the past, it would be, oh, I need it in 3 months, but now they will say we need it now. So really about managing client expectation more than the law itself.
I'm going to go ahead and cut off that answer, and we're on our last minute here. So 20 seconds or so each on, in this changing environment, what's the most important takeaway for our audience to leave with?
I would have to echo what Tamina said earlier, and we need comprehensive immigration reform because all of these executive orders are in fact just band-aids, some good and some bad. So if you want comprehensive immigration reform and want all of this to make sense, then I would urge you to contact your representative and senators.
I would echo what he said, but I also would add that if you really care about this issue, have your voice heard. You could write a letter to the editor. You could speak up for your friend or family that's being affected. Your voice is important, and every single voice is important. It's a bit like drops make oceans. We are in a time where everybody's voice is going to have to become louder. And I wrote an article once called 12th Man for Immigration Reform. I think that this is really, honestly, the time that the 12th man on immigration needs to stand up.
That's a perfect send-off. Ching ching.
I think involvement in education are becoming more and more important. We really need to learn the issue, and as practitioners, I feel it is more urgent than ever that we actually go out to the community, do our outreach, and really talk to the members, let them understand the issues, and I think that's getting really important. Yeah.
Well, we are at time, and I want to thank everybody here in person and on the interweb for joining us today. The fact that you're here spending an hour with us over lunch, we appreciate your focus and attention on the issues. Megan, do you have any follow-up you'd like to bring in?
I just want to remind everyone that this is a two-part panel, and we will be meeting again next Tuesday from 12 to 1 to discuss the more personal perspective on immigration, so going from macro down to micro, and we really hope you'll all join us there.
We'll see you then.